Hey guys, good evening, good evening, good evening. I know it's late. Well, good morning for some people. I know it's really late, but I have something to share with you guys. Shout out to Mr. 444 Smiles. You know, he's working late at night trying to get some information out. Good evening, Tamisha. Good evening, Henny Hen and Karen. Henny Hen, what are you doing up? You know you got to get to work tomorrow, so why are you up? Hey, Shar. Well, Mr. 444 Smile has been sending me stuff all night, and just him brainstorming of some things that has been he's been thinking about and getting done for Robert's case. So he brought up interesting article. You guys remember the attorney Tamia? I don't know, but the one that's been at the trial. Well, she spoke of a motion that Robert's team can send out. So Mr. 44444 Smile, he oh, you off tomorrow? Okay. He went and did some research on it, and I wanted to share something that he got in regards to that. So the 330 motion for a new trial, and I'm gonna play this audio thing he has for me. So I'm gonna play it now so you guys can hear. Okay? All right, here we go. This is just to help you understand what that is all about, okay?
A potential client, and he asked a question, what is a 330 motion in New York, and gave me an idea for this video. So Miguel, if you're watching, thanks for the idea. And if you are not Miguel and you're watching, thank Miguel for this idea. So I get asked this several times. What is a 330 motion in New York? And a motion for a new trial or to set aside the verdict under Article 330 of the New York Criminal Procedure Law. And the specific section is New York Criminal Procedure Law Section 330.30, is a motion that has to be made after the verdict, but before sentencing. And in that motion, you ask to set aside the verdict and either dismiss the case or grant a new trial. Now, there's three separate grounds for a 330 motion by statute. The first ground is, I'm going to read them to you and then I'm going to kind of unpack them and explain them a little bit. But the first ground is any ground appearing in the record, which if raised on an appeal from a prospective judgment of conviction, would require reversal or modification of the judgment as a matter of law. The second ground is that during the trial there occurred, out of the presence of the court, improper conduct by a juror or improper conduct by another person in relation to a juror, which may have affected a substantial right of the defendant and which was not known to the defendant prior to the rendition of the verdict. And the third ground is that new evidence has been discovered since the trial, which could not have been produced by the defendant at the trial, even with due diligence on his part, and which is of such a character as to create a probability that had such evidence been received at the trial, the verdict would have been more favorable to the defendant. So let me kind of go through each one of those. So the first one is any ground appearing in the record which would result in a reversal on appeal. And basically that means, let's say the judge makes a mistake at the trial. The judge admits certain evidence or permits the prosecutor to make a particular ruling or makes a particular ruling about a jury instruction or whatever the issue is that you would otherwise appeal. The 330 motion gives you the ability to actually ask the judge to reverse themselves and correct the error by granting a new trial, thereby saving everybody the time, trouble, and expense of an appeal. There's a couple of problems with this. I mean, first, let's all be honest with each other, right? Human beings never like to admit that they are wrong. Any married person will tell you this. For better or for worse, judges are human beings and they are no different than the average person. So a judge is probably loath to admit that they are wrong if they made a ruling and say, oh yeah, you know what? I totally screwed up. Let me fix this and give the defendant another chance to get an acquittal. Probably not going to happen. The problem comes along is, let's say a judge makes a ruling and it's on a very, very, very shaky ground, right? The logic that the judge used or to make the ruling is not sound, or the reasoning is not sound, or let's say the judge cited no law or cited the completely wrong law in support of the judge's position in making a particular ruling. If you file a 330 motion, you give the judge and the prosecutor the opportunity to clean up what would otherwise be a very messy argument that you can attack easily on appeal. And now they can say, you know what? That's not what I meant. What I actually meant was, and fix the problem always to the defendant's disadvantage. So that's one problem with making a 330 motion on this particular ground. And that's why I usually advise people not to do that. If you're going to get relief on any ground in a 330 motion, it's always going to come in the second and third grounds, almost always. So let me give you a real world example. Let's say this is actually a case that actually happened in Queens several years ago. So everybody knows that when you're doing a trial, the judge specifically advises the jury, number one, do not discuss this case with anybody except your fellow jurors while you are in the jury room and I've given you this case to deliberate. Up until that point and beyond that point, you do not discuss this case with anybody until you're released from jury service. That's rule number one in every trial. Rule number two is the jury has to promise the judge that whatever the judge instructs them on the law, they must accept that instruction without reservation. They have to follow the law as the judge gives it to them. And they can't go do their own research or anything like that. So in this case in Queens, the jury is deliberating one day. The judge has given them the final instructions, and the jurors go home for the night. And that night, one of the jurors gets it in his head that he doesn't think the judge is right. So he calls on the phone an attorney friend of his and says, hey, attorney friend, this judge told me that this is the law and this is what I should be focusing on. The lawyer tells him wrongly, no, the judge is wrong on the law. This is what you should be focusing on, and tells the juror a different version of the law than what the judge does. The next day, the juror goes back to the jury room. They start deliberating, and he tells all of his fellow jurors, well, this judge is wrong. He doesn't know what he's talking about. I spoke to a lawyer last night who's a friend of mine, and this is what he said. Well, wouldn't you know it? That's violating two very big rules. And that is the type of thing that would not be known because it's happening outside of the courtroom. That's the only way you find that out is when one of the jurors rats out that one offending juror, which of course is what happens, and that forms the basis of a 330 motion. The third basis of a 330 motion is what's called newly discovered evidence, and I get asked this all the time. Okay, what is newly discovered evidence? That's not something you just found out about because you just picked up the file or you didn't realize was there before. Newly discovered evidence is a kind of evidence that nobody could have found with due diligence, meaning if everybody had done their job, the defense lawyer, the investigators, they'd done their job and they could have found this particular evidence, but they didn't find it because they were negligent or because, whatever the situation was. That is not newly discovered evidence. What is newly discovered evidence is when they could not have possibly found it. So a new witness comes forward that nobody else knew about before. Somebody sees something on the evening news and says, oh, yeah, you know what? I was there. And their name doesn't appear in a police report, doesn't appear in any of the discovery, anything like that. Sometimes it's new technology. New technology comes along, and like DNA, for example, and technology wasn't available 20 years ago. But new technology comes along and you're able to prove something that you were never able to prove before. So that's what newly discovered evidence is, not something you just learned about now. But in reality, in a 330 motion, in that type of situation, because this has to be in that very narrow time window between verdict and sentencing, it's very hard to find newly discovered evidence that fits the legal definition. So if you have any other questions, please email me. Please stay tuned for this important announcement. You'll be able to contact me, and thanks for watching.
Y'all heard that, right? Did y'all hear that? You want me to start it over again? You want me to play it again? What the 330 is all about? Would you like me to play it again? Those who are just coming into the chat, would you like me to play it again? Do you understand what I just played? What a 330 rule is? Let me know if you'd like me to play it again. Give me a thumbs up if you want me to play it again. A couple of people coming in now. I know it's late, and I just wanted to share that. Hey, Golden Girl. So do you guys want me to play it again? Okay. T-Boz, definitely. I'll play it again right now for you. Guys, I just here. Play it, please. Okay, I'll play it. Okay, Sandy, I'll play it. Stand up and be counted too. Okay, Kanik said he is following the motion, but he needs to. He said what kind. He didn't say what kind. Okay, but I'm gonna play this for you guys again. All right. Shout out to Mr. 444. He's the one who found this information for me. So I tell you, these guys are the bomb. Tickety bomb. All right, here we go. This is a 330 motion for a new trial, and they're giving you the 3 reasons that you would file for the 330 for a new trial. Here it is.
So this week I was actually speaking to a potential client, and he asked a question, what is a 330 motion in New York, and gave me an idea for this video. So Miguel, if you're watching, thanks for the idea. And if you are not Miguel and you're watching, thank Miguel for this idea. So I get asked this several times. What is a 330 motion in New York? And a motion for a new trial or to set aside the verdict under Article 330 of the New York Criminal Procedure Law. And the specific section is New York Criminal Procedure Law Section 330.30, is a motion that has to be made after the verdict but before sentencing. And in that motion, you ask to set aside the verdict and either dismiss the case or grant a new trial. Now, there's 3 separate grounds for a 330 motion by statute. The first ground is, I'm going to read them to you, and then I'm going to kind of unpack them and explain them a little bit. But the first ground is any ground appearing in the record, which if raised on an appeal from a prospective judgment of conviction, would require reversal or modification of the judgment as a matter of law. The second ground is that during the trial there occurred, out of the presence of the court, improper conduct by a juror or improper conduct by another person in relation to a juror, which may have affected a substantial right of the defendant and which was not known to the defendant prior to the rendition of the verdict. And the third ground is that new evidence has been discovered since the trial, which could not have been produced by the defendant at the trial, even with due diligence on his part, and which is of such a character as to create a probability that had such evidence been received at the trial, the verdict would have been more favorable to the defendant. So let me kind of go through each one of those. So the first one is any ground appearing in the record which would result in a reversal on appeal. And basically that means, let's say the judge makes a mistake at the trial. The judge admits certain evidence or permits the prosecutor to make a particular ruling, or makes a particular ruling about a jury instruction or whatever the issue is that you would otherwise appeal. The 330 motion gives you the ability to actually ask the judge to reverse themselves and correct the error by granting a new trial, thereby saving everybody the time, trouble, and expense of an appeal. There's a couple of problems with this. I mean, first, let's all be honest with each other, right? Human beings never like to admit that they are wrong. Any married person will tell you this. For better or for worse, judges are human beings and they are no different than the average person. So a judge is probably loath to admit that they are wrong if they made a ruling and say, oh yeah, you know what? I totally screwed up. Let me fix this and give the defendant another chance to get an acquittal. Probably not going to happen. The problem comes along is, let's say a judge makes a ruling and it's on a very, very, very shaky ground. Right? The logic that the judge used or to make the ruling is not sound, or the reasoning is not sound, or let's say the judge cited no law or cited the completely wrong law in support of the judge's position in making a particular ruling. If you file a 330 motion, you give the judge and the prosecutor the opportunity to clean up what would otherwise be a very messy argument that you can attack easily on appeal. And now they can say, you know what? That's not what I meant. What I actually meant was, and fix the problem always to the defendant's disadvantage. So that's one problem with making a 330 motion on this particular ground. And that's why I usually advise people not to do that. If you're going to get relief on any ground in a 330 motion, it's always going to come in the second and third grounds, almost always. So let me give you a real world example. Let's say this is actually a case that actually happened in Queens several years ago. So everybody knows that when you're doing a trial, the judge specifically advises the jury, number one, do not discuss this case with anybody except your fellow jurors while you're in the jury room and I've given you this case to deliberate. Up until that point and beyond that point, you do not discuss this case with anybody until you're released from jury service. That's rule number one in every trial. Rule number two is the jury has to promise the judge that whatever the judge instructs them on the law, they must accept that instruction without reservation. They have to follow the law as the judge gives it to them. And they can't go do their own research or anything like that. So in this case in Queens, the jury is deliberating one day. The judge has given them the final instructions, and the jurors go home for the night. And that night, one of the jurors gets it in his head that he doesn't think the judge is right. So he calls on the phone an attorney friend of his and says, hey, attorney friend, this judge told me that this is the law and this is what I should be focusing on. The lawyer tells him wrongly, no, the judge is wrong on the law. This is what you should be focusing on, and tells the juror a different version of the law than what the judge does. The next day, the juror goes back to the jury room. They start deliberating, and he tells all of his fellow jurors, well, this judge is wrong. He doesn't know what he's talking about. I spoke to a lawyer last night who's a friend of mine, and this is what he said. Well, wouldn't you know it? That's violating two very big rules. And that is the type of thing that would not be known because it's happening outside of the courtroom. That's the only way you find that out is when one of the jurors rats out that one offending juror, which of course is what happens, and that forms the basis of a 330 motion. The third basis of a 330 motion is what's called newly discovered evidence, and I get asked this all the time. Okay, what is newly discovered evidence? That's not something you just found out about because you just picked up the file or you didn't realize was there before. Newly discovered evidence is a kind of evidence that nobody could have found with due diligence, meaning if everybody had done their job, the defense lawyer, the investigators, they'd done their job and they could have found this particular evidence, but they didn't find it because they're negligent or because, whatever the situation was. That is not newly discovered evidence. What is newly discovered evidence is when they could not have possibly found it. So a new witness comes forward that nobody else knew about before. Somebody sees something on the evening news and says, oh yeah, you know what? I was there. And their name doesn't appear in a police report, doesn't appear in any of the discovery, anything like that. Sometimes it's new technology. New technology comes along, and like DNA, for example, and technology wasn't available 20 years ago, but new technology comes along and you're able to prove something that you were never able to prove before. So that's what newly discovered evidence is, not something you just learned about now. But in reality, in a 330 motion, in that type of situation, because this has to be in that very narrow time window between verdict and sentencing, it's very hard to find newly discovered evidence that fits the legal definition. So if you have any other questions, please email me. Please stay tuned for this important announcement. You'll be able to contact me, and thanks for watching. If you like what you just saw, please click like and subscribe to our YouTube channel, Appeals Law Group. Please make sure that you follow us on Facebook at New York Weekly Roundup. Follow me on Twitter at PM Magaro, and please check out our website at www.appealslawgroup.com.
All right, guys. So that's what it's all about. Did y'all hear it? Did y'all hear what I just played? Did y'all hear what that 330 rule is? Did they follow 330? I don't know, Samantha. But that's what that attorney was talking about. Oh. I think I touched the. What did I just do? What did I just do? Hold on. I got this. Where my mouse? I think I dropped the mouse, y'all. Can this 330 apply to Robert? There's quite, yeah, definitely it can apply because there's a lot of things. Because we even found some stuff. Hold on. Sorry about that. My mouse fell. Sorry. Yeah, I think it can file a 330 because there's some stuff that was that are found that are found. Uh, yeah, definitely. You heard that? Okay. Everything falling off this bed here. Sorry about that. Seems to me the jurors exactly T-balls. Yes, I was thinking the same thing too. Okay, here's what I want to tell you. I remember they sealed the notes from the juror note, right? They sealed it, right? And but they let the jurors verdict sheet show. So I'm thinking there's something that happened that they noticed in the jury notes, right? For example, I'm just giving you because I don't know because it's show closed in and I don't know if it's actually open or not, right? But I was also told like if a juror had put in their notes like guilty already on it, like say they doodle in the word guilty, right? This is way before they go into deliberation. They say they just got the paper the first day, and because they couldn't take those notes home with them, they had to leave it behind in court every day. Say the first day on a piece of paper, they had already wrote him guilty. That means they had that preconceived idea even before they heard all the evidence that this person was guilty. I'm just giving you an example. And say it was on that piece of paper, they thought they were just doodling, but no, it was actually part of it. So I'm just throwing out something. It's nothing that's concrete, but I was just, throwing out something. Because why is it that the jurors' notes are sealed? Hmm, isn't that interesting? That's never sealed before, unless something happened. Isn't that interesting? Hmm, what you guys think? Ah, he says, I thought I don't know anything about law, so no comment. I refuse to make such speculation. We're just having conversation, Felicia. We're just having conversation. None of us know law. Heard the jury bases their verdict on docu. What if you told they had the verdict Friday before they left? Then that means they lied. To me, the instruction was highlighted for jurors to convict Robert, and two, that's not right. Dana. Yeah, Karen, yeah. Seal equals hiding something. Yep, that's what it does equal. Hiding something. Mm. And you know what the thing is? Let me tell you something. The judge said about filing the motions. After she gave the verdict, what they were, because you should have seen her face when they were giving the verdict. You should have seen the judge's face. Why they seal liar 5 testimony and some of it instead of impeaching? It's like judge said she would. I don't know, Felicia. I don't know. I don't know. But that's what 330 is all about. She did mention another violin. I think it was a 29 and a 330. I think that's the two things she talked about. the attorney. I could play her. Let me play her live for y'all, so you can hear what she had said. Hold on. Shout out to the attorney that was at court. Shout out to her. But I had told Mr. Small 444 Smiles um about it, and he went and started doing some research. I was telling him what she had said, and he did some research, and that's where he found that. Shout out to him. Shout out to Mr. 444 Smile. Okay, let's see. Let me go play it for you guys so you can hear her. Just a second. Just a second. Just a second. Okay, hold on, guys. Gotta find her. Where did somebody send it to me and now I can't find it. Anybody got that attorney um message? The one that was in court? Because somebody sent it to me. I gotta figure out who is it that sent it to me. Oh God, what was her name? You guys send me so much stuff that I don't know who sent it, which page it was on. I was watching it the other day. Let's see. Maybe it's on the other phone. Oh my gosh, where is it? Maybe it's this one. Is it this one? You guys have been sending me some good stuff. Well, let me see if it's that one. Oh. Cannot find it. Anybody have the information on that attorney? The one that was at court. The one with the bang. Somebody got it? Could send it to me. Hold on, let me go into my Instagram. I think it's in my Instagram. I think she's in my Instagram. Hmm. Uh-uh. Hmm. Hold on, y'all. Hold on. Just bear with me a second. I'm trying to look for it. Tamika, try not to put people's name in the chat that are not here. Please. Please try not to put people's name that's not here in the chat. Ain't nobody involving themselves in the chat in the no, I never contact the attorney. This is me doing my commentary on my channel. I ain't involving nobody's stuff.
You will need to do that in the TV app.
Okay, here we go. Tamika, let's see. No, not Tamika. Tamia. Hmm. Interesting. Karen, I don't know where he is. He probably in the bushes somewhere. It's okay, Karen. No, Dom name is fine. I'm talking about the other person name that Tamika put in there. Mm-mm-mm, mm-mm-mm. Ace Man, hello. Don't laugh, Ace Man. Don't laugh. Don't laugh. Don't laugh, Ace Man. I'm trying to get the attorney's thing. Somebody had it in here. I'm trying to find it. Is Anna, if you're in the bushes, what was the thing you sent me? What was her name? Let's see. I'm trying to find it, y'all. I am trying to find it. Let's see. See if this is it. No,
Okay, so
that's not it. That's not it. That is not it. That is not it. Let's find it. Any news? No, change is good. No news. I was just I would hope so, Ace Man. I don't know, that's something you heard? Where we're about to eat it out? I don't know, Gerald. Where do you want to eat? It's too late to eat. It's too late to eat. I thought you wasn't coming back tonight. Oh, Christy, let me tell you what happened. Mr. Small 4444. It's a new day. It's a new day. I'm not here. It's past 12 o'clock, so I didn't come back last night. So I didn't come back last night. It's a new day, Chrissy. Okay, I'm trying to find Chrissy. What was that attorney name that sat across from me and I was talking to her? It started with a T. What's her name? Tamia? Online, and I saw acquittal as a result of not guilty that cannot be prosecuted again. So what are the hitting Rob with the 2008 stuff? They didn't charge him with 2008 stuff. Not listing the lead. Banana pudding. Thank you, Tennille. Okay, thank you. I remember her now. Thank you, darling. Appreciate it. I'm gonna go look for her up now. Nope, it's not on here. I think you spell her name wrong. I can't find it. Erica, is that the name? Oh, okay, there it is. Thank you. Tell me. Okay, hold on. Let's see. Temani Adams. There she is. Thank you. Okay, here she go.
Christmas, because your Christmas should look like you. All right. The jury came back guilty on all counts for R. Kelly. And they came back extremely quickly with just one full day of deliberations. The jury got the case last Friday afternoon and came back with their verdict today, Monday. Today's afternoon. They did not work over the weekend. And keep in mind, on Friday, they even sent a note to the court about like during deliberations. So they came back very quickly. I've had juries on drug cases come take longer to deliberate than they did on this case, which is an indication to me that the jury had their minds made up. Because of the amount of evidence that was involved, there's no way that the jury, reviewed all of the evidence, because there were letters, there were lots of things taken from his storage, and there were videos. Just reviewing the videos and the letters alone would have taken more than a day. So I guess the jury said, hey, we don't see any of that or any more of that, and they made their decision. I have to be honest, I think part of the decision that they made was emotional because of, when cases involve children or minors in the appropriate sense, and if there are parents on the jury, then people take that with them, and especially when a lot of the witnesses in the case, they testified to things that were not crimes, but they showed a pattern of behavior. So those are things that I'm pretty sure that the jury considered in their verdict. So what's next is a pre-sentencing report will be created. We call it a PSR. A PSR is a report that's created which tells the judge more information about R. Kelly personally and about the offense. And at the end, it gives a sentencing range for the offense. Now, the PSR, the interview is done with Mr. Kelly, his attorney, and the probation officer. The probation officer also gets information from the government or the government witnesses as well to create the report. So the first part of any PSR is about the person, age, where they grew up at, siblings, marital status, kids, where the kids live, is he on child support form, his financials, and they ask for financial information because they want to know if the person can afford to pay a fine. They also get the person's credit report, all types of stuff. They also get information about the person's family, how they grew up, were their needs met, were they victim of a crime or any type of abuse when they were a kid. And from there, the report begins to talk about the offense and the details of the offense. And because he has so many different counts, each count gets assigned. So let's just say he has, 20 counts or whatever it is. So there's a section for each count. So let's just say one of the racketeering counts. So it's like, oh, this is the statute for this. this is the base offense level. Now, the offense level is a number that's assigned by statute for the offense. So a base level racketeering, the base offense level is 19, but it can be different depending on various factors. So let's just say the racketeering has a base level of 19. Then from there, if there are any type of enhancements that are available, then the enhancements are added. So let's just say in a standard robbery, Hobbs Act robbery in the federal system, my client has a gun during the robbery and he brandishes it or he fires it. There's another 5 to 7 point enhancement on there for whatever acts he did with the gun. So that would take the whatever the base offense level up by however many points it is. So from there, we go through that to the PSR, however many counts it is. And then if some of the counts fall under the same statute, that's what we call grouping, which is saying, okay, well, these offenses are all under the same statute. So these offenses, we're going to, let's say it's 4 racketeerings, then we're going to add 4 points to the overall offense level. And from there, at the end of the report, there is whether or not there should be a fine, if there's restitution, and his punishment range. Now, from what I understand, R. Kelly has 0 criminal history. So in the sentencing guidelines, let's back up. Criminal history is assigned through categories. So there's a category 1, 2, 3, 4, 5, 6. Criminal history category number 6 is the worst. So in that situation, if you have a category 6 or 2 or whatever it is, you're facing more time than someone who's in category 1, which means they have little to no criminal history. So R. Kelly is going to be in criminal history category number 1. So if his offense level was 19, then you get the range by that cross point, and that's pretty low. The charges that carry the most, the highest offense level is the Mann Act violations. But even with those violations, with no criminal history, his punishment range is still low. And keep in mind, he has 2 years or almost 2 years of back time. I'm not sure if all the back time applies to this case, because he also had some that was some back time that he got from the Chicago case. So they may or may not give him credit for that, depending on whether or not the indictment for the Eastern District was already out and if they had a detainer on him. But either way, that's just lawyer talk. So his range is pretty low because he has no criminal history, plus he has his back time, and he will get credit for his time served that he has served. Let me rephrase that. But one thing that I expect is for the government to file a request for what's called an upward departure. And an upward departure says, yes, judge, we know that this person has very little criminal history and that his punishment range is low. However, we think this person is a really bad person, or the sentencing range does not fit the crime. So, judge, we want you to consider the full statute, the full range under the statute. So let's go back to, let's just say, a drug case. And let's say the client's punishment range is 30 to 36 months. However, my client was, a really bad guy and, branded some girl with a hot iron, and she's traumatized for life and has PTSD, and he kicked a kid or something like that. The government can say, oh, no, judge, even though his range is 30 to 36 months, the full punishment range is 0 to 20 years. We want you to sentence him higher than what his range is. And that's common practice, especially in cases like this, where the person is accused of doing something really bad, but they have little criminal history. So, however, the defense, I'm pretty sure, because it'd be horrible if they didn't, should file what's called a request for a downward departure. And when a downward departure says, hey, judge, we know the range is X, Y, and Z, but we would like for you to depart lower and sentence him lower than his range because of these factors that we're going to list in this motion. Now, the thing is, the judge can do whatever he or she wants. The judge does not even have to follow the range that is recommended. The judge can consider the full range of punishment under the statute. If the statute says you can consider 0 to 20 years, she can sentence him to 0 to 20 years based on her own whatever. Also, for sentencing, the PSR. So you have the PSR interview, the report is created. Each side gets to file objections to the PSR. Let's just say from a defense perspective, I think that no, a sentencing enhancement should not apply, or that the probation officer got certain facts wrong. Those are things that I filed in my objections to the pre-sentencing report. And the government can do the same thing. They can say, oh no, the probation officer got this wrong, this should be that way, and so on and so forth. From there, each side submits their objections. The probation officer who does the report goes back, reviews each person's objections, and he can agree or disagree with them. If he agrees, he changes it. If he doesn't agree, on the date of sentencing, the judge determines whether or not the objection is sustained or overruled. And if it's overruled, that means she does not agree with the objection. If it's sustained, that means she agrees with it. And that will change his offense level right there in court. So, and by the way, the PSR is something no one is ever going to see other than his attorneys, the government, and the judge and the probation officer. PSRs are confidential. Also at sentencing, each party can present witnesses. I'm pretty sure the government is going to present witnesses. Hopefully R. Kelly's team is going to present witnesses, and a lot more than what they presented for his defense. They only brought a handful of witnesses compared to the government's 45 witnesses. And the problem with that is this: jurors want to see information from the defense. I've had that happen in a case, and the government had lots of exhibits or evidence in the case. In the defense, we didn't have as many because we don't have the burden of proof. And each juror is informed of the burden of proof and that we aren't required to present anything. However, jurors still told us that, no, we wanted to see more from you all. That case ended in a hung jury, but it's the same thing in this type of case. Because if the government can bring 40 plus witnesses and you only bring 5, it's just like, even from a common sense perspective, it's like, well, yeah, I know I'm supposed to not consider that, but why does he only have 5 witnesses? So yeah, that was pretty tough. Now, appeal. Everyone who goes to trial in a federal case has the right to appeal. That's not going to change. You can file a notice of appeal 14 days after the judgment. So they can file a notice of appeal now. They have 14 days from now to file a notice of appeal. But typically, you don't file a notice of appeal until after your client has been sentenced, because if you file it now versus after their sentence, there may be issues at sentencing that you also want to appeal. And it would be pointless to file the notice of appeal now because you don't know what's going to happen at sentencing and whether or not you're going to have a basis for appeal for any of those things. There's also several post-trial motions that can be filed. Most commonly are a Rule 29 motion and a Rule 33 motion. A Rule 29 motion is basically saying, hey, judge, we believe that based on the facts and the evidence, the jury got it wrong. Those motions are rarely granted, and I guarantee if the R. Kelly's defense files one in this case, it's going to be overruled. It's just something you do to preserve your record for appeal. Also, you can file what's called a Rule 33 motion, which is a motion for new trial. I've done these before. These are more commonly granted than Rule 29 motions. There are 2 types of motion for new trials. The one that I see most commonly and the one that I've done most commonly is a motion for new trial based on new evidence. You have 3 years from the date of the judgment to file a motion for new trial based on new evidence. They may or may not get new evidence, but they definitely should. One of the things that I definitely would be doing at this point is getting my investigator ready to go out and talk to these jurors and get more information from them and get feedback from them. Now, government and the defense, they are now able to speak with the jurors if they want to speak with them because the case is now over. So when speaking with jurors, you may get some great information that you can use for appeal. Now, this case, from what I understand, he was offered a plea deal and didn't take it. And I said this before because the outcome of this case would likely affect the outcome of the other cases. So, say for instance, if he got found not guilty on this case, these prosecutors in Chicago may say, hey, we may or may not move forward with this case because we're going to have the same similar witnesses and we may have the same issues. So it may not be the best case thing to retry the case in Chicago or do the case in Chicago, because it may end up in the same result. Or in this case, he got found guilty, then R. Kelly may be willing to enter into a plea agreement for the Chicago case to go ahead and get it over with and get on to where he's going. So after sentencing, an inmate is assessed by the BOP, which is the Bureau of Prisons, for their custody level based on their criminal history and their offense, and they are assigned to whatever jail the BOP assigns them to. Per the First Step Act, now the BOP has to try to place someone in a jail at least 300 miles or within 300 to 250 miles from their home. So that's one thing. However, he won't be sent straight to BOP custody because he still has the case in Chicago. So he probably won't go into BOP custody. And let me just say this, he's in BOP custody now, but I mean BOP custody as far as going to his assigned jail or penitentiary, however you want to put it. So he won't be going to his assigned facility until the other case is resolved. Just in case they do send him to his assigned facility, he will be taken back to Chicago at some point and taken to a different facility until the Chicago case is resolved. And those are my thoughts on the verdict. Send me any questions. I will make an ask me a question post on Instagram for any questions that you all have. Have a good day.
Alrighty. So, how was that?
Goes on the road.
Speaking of favorite teams, let's talk about my son.
Sorry. So, guys, did you understand what she said? The witness, the judge, Corey, the judge didn't allow some witness, and there were not 35 witnesses on the list. There were not 35 witnesses on the list. The sentence is far off, never seen anything like this before. Yeah. See, Queen Christy was at the court. You have to ask the people that was at the court. I was at the court. You had Dottie, you had you even had Glenda, you had who else? You had Daddy Lolo, you had yeah, those people at the court. So I don't know how much credence you're going to give to somebody that was never at the court. That's all I'm saying. That's all I'm saying. Travel, so that case is time served, but that's judge is ruthless. When questioning jury, his attorney should ask, did they watch the surviving R. Kelly? I think they did ask them that, but they let some of them stay. You know what? I'm gonna read one of the sidebars that you guys, so you guys could see what was going on. One of the sidebars, and Yeah. See, Queen Christie could tell you it was asked. Prosecution led the witnesses into their response, and the witness, developed amnesia during the cross-examination. Yep, and even the judge at one point said something about impeaching Asriel. So I don't know what happened with that. Pray God expose all the clowns. Hey, madam. Psalms 91. When asking the jurors. Okay, hey, Robbie. This is messy but Robert will push through. Amen. Amen. Yeah, let's see. I was trying to read your messages. But it's no matter. Okay, it says, okay, Cannon was lead. He took the credit for the win. So he got to take the credit for the loss. Still could have argued against the RICO. He did argue against it, Corey. That's why we say read the transcript and you'll see everything that happened. No matter how many witnesses defense brought to the stand, it was going to be guilty. Sony's behind this. I could concur. Here's the deal. It was already set up. Listen to Gerald. It's already set up that way. They blacked out the part of the transcript. Remember, sis? Yes, they did. I actually thought 3 of the witnesses' testimony could have been thrown out. Me too. Plus they changed the language and changed the rules in the middle of it. First she said that she wasn't going to accept any videos, and then she saw that the prosecutor was being slaughtered, and she made some changes to the rule. She changed a lot of things. Even the language at the end she changed. She changed a lot of things. You guys should have been there. You would have seen what we were talking about. Oh, I forgot. They changed that too. Only 8 of us could get in. Oops, my bad. And we saw this other case. A whole bunch of people was coming in this other case. They were having a murder case. Oh, well, I guess it was a setup. Got guilty. Found guilty. Yep, Corey. I don't think it was anything anybody could do. Okay. I'm telling you, you saw how we came out. When we came out, we was all excited because Kenneth was killing them on the stand. Oh my God, that man was killing them. They kept saying, "I don't remember. I don't remember. I don't remember." And then they read the thing, and they were saying it was a inconsistency, and they all lied. There's no possible way. That's why I said when I came out, if he's found guilty, that means it's a setup. I knew it then. I said it. Yep. Donnelly rejected the expert that was going to come in and speak against the other expert that showed up. She said she wasn't going to allow the testimony of it, right? Then there was another part where what's it? Yep, Koenig said, "Allow me to refresh your recollection. Did y'all ever read Belle Biv DeVoe lyrics? Do me, baby." They rapped about what's going on in backstage with underage adolescents. Shake my head. These dudes are sick. Madam, Psalms, you know what? Let me tell you something. The whole industry is sick, if you ask me. The whole industry. You know, it's rigged. So many people I can name that the majority keyword was not collected. Yep. A lot of, let me tell you, Keandra Jones, the one that's supposed to testify, they had gotten, they got her for prosecutor, who ended up getting her. It's like whatever person that the defense had, ready to call, they end up calling them, and if they get to them first, they become a witness for the prosecutor. It's so weird. It's weird. Which detective? You talking about the Palladino? He got killed in the beginning of the year. He died. I'm telling you what I know. The verdict was reached. You're right. No loyalty. You're absolutely right. The jurors went home. The verdict was already reached. There's no possible. There should have been at least one person that said not guilty. The judge and jury should be investigated. It's a lot of shady stuff that was done on that case. A lot of shady stuff. How do you not let the man? Okay, the other thing too, y'all. Remember the person that was supposed to come in and testify? She supposedly got sick, but then still her stuff was submitted in. There was no possible way for them to cross-examine because they just let her evidence was taken in without her testimony because she was scared. The one girl did with the interview again. Yeah, they didn't let that one in. They let a lot of videos in. And everything they kept doing, you saw all the objection they had. Yeah, y'all saw that. It's cold. I got to put my covers on. Susan Logan didn't come. A lot of that the jury was tainted. Yep. They didn't sequester them. They went home. They know they talked to somebody. Truth is gonna come out. Says we already knew what happened to defense money. So why Dr. Rice said the blogger needs to speak on that. I don't know nothing about the money, so I can't even speak on the money. What was being said on The Voice with the TBD and Dr. Rice? Oh. Don Russell, not Dr. Rice. That one was the video that they did back in January when Don Russell was showing the pictures of what's that girl name? Was she showing pictures of Faith? That's what was shown. Travel says the black detective, Miss Sylvia is whom I'm asking about. What are you asking about him? I don't know what you mean. What are you asking? Travel. I have one in the feds and two in the state. I have been done firsthand. I have seen it done firsthand. Intricate setup planned years in advance by the government, rolling out the plans for friends, and with the money to get high position. Robert is political prisoner. I agree on that one. Thanks. How was that relevant to? They try to say, okay, here's what they're saying. They saying that Don Russell was part of the enterprise. He was the one making threats to the alleged victim. So that's how they connected the enterprise. It says, have you seen R. Kelly's cousin's channel? Levi Kelly just found his channel. The government got them too far, and they got their conviction and made $2 million for the government. As soon as those Jews were allowed to speak, someone's lip got loose, and they know why they came on the verdict. They got. Wasn't he working a defense team and finding out days? Guess that's what detectives do. Let's see. Wow, RSK was being charged for what person? That's what I thought. I couldn't use that against them. Yeah, I thought so too, but that's what they said. We put it in there. The one that they didn't put in there was the car burning. The car that they didn't put that in there. They put the bomb threat in there. They put that one in there. And of course the threatening, because they actually mentioned their names in the question. It says he's live one night, and he called another blog about that defense fund. Rita, hey. The Rita. It's a bunch of readers in here. Would you? I don't know. Oh no, I had to yawn. Sorry, y'all. I'm getting sleepy. I'm about to leave y'all in a minute. Hit the sack because it's 2:00 in the morning. Would you? Why didn't they use Geronda's sister letter about her lying and use the new discovery of that evidence? I don't know, y'all. I don't know why the judge refused some things. Just like the parents. They said that they couldn't bring the parents' name, parents involved, and then when she was doing her examination, they let stuff in for. It was just crazy, yo. It was just crazy. Rita, he is not. He is, and he's not making any good points. Oh, what are y'all talking about? You need some rest, and then I'll be. Yeah, I'm about to go hit the sack now. I just want to give y'all that information. I just want to give you that information. And I'm going to say this one more time. All you guys come in here talking about something that Sharon has said. Sharon did not come to one court date. She has not been to any marches. You don't even know who she is. And how in the world you guys come in here and regurgitate what she says to me? That's pretty sad. That's very, very sad that you would come on a channel where you've seen a person go and you've seen. I hope everyone. The petitions has been signed. The ones, yeah, the one, but yeah, we signed it over here. You've seen people go to marches and go to the court supporting. You have never seen that woman. You don't even know who she is. But for some strange reason, you want to come over here and give me a message from her. It's really sad. It's really, really sad. She has never, ever, ever been to the courtroom. I have not seen support just from the sideline. Got so much to say. Just words, no action. And it's really sad. It's really sad. But you want to come and put her comment in my chat. It's really sad. And this is the same person who has so much intelligence, but when she went over there to the True Dana and with Judge Joe Brown, she didn't even know what the whole Black Caucus format, how the Black Caucus come into play. But she knows everything. She knows everything, but didn't want to tell you that big cousin haven't. You see, I come after those that come after me. Who gonna check me? You know what? I ain't saying nothing. You just gave me a laugh just now. But she came after me. She's done so many videos on me and telling I hired guys. I have never hired any. I've never talked to Kanik in my life. Never, ever. And my phone has never dialed that attorney's number. But all of a sudden, I'm part of hiring him. Oh my God, this woman just delusional. She's so delusional. She's mad because I didn't answer her call when I was at the airport. She called me. I called her back. She called me again. I didn't answer. So she's mad at me. So now all of a sudden I hired this person. I hired that person. I've never hired anybody. I don't even call Kanik. I've never called Kanik. Yep, they sure have. They're sad. But I've never, ever, ever called Canic. You didn't see me chasing after Canic either. I didn't chase after Canic. I let the man do his job. So I just told him, hey, good job when I was sitting on the bench where y'all saw me. So all this extra stuff. The reason I say something about that woman, because she's been doing how many videos on me? That woman has done so many videos on me. It's ridiculous. While she sat behind her flower pot. Mm, mm, mm. And some people come in my chat. Something's wrong with you that you would follow somebody that you don't even know, to have never seen. Don't even know what she look like. She could be right in front of you. You won't even know it. She got so much to say. Sylvia, they blame you for everything because you. Who gonna check me? Yes, they do. They blame me for everything. Somebody hit their toe. It's Sylvia's fault. Sylvia did it. I tell you, Sylvia do everything. Hey. Everything I did. Everything. Lord have mercy. I've done everything. Hired the attorney. So they don't like the attorney now. It's my fault. Mm, mm, mm. She's full of thorns. Yes, she is. Oh, but I've done everything. Yeah, I've done it. I've sure to tell you. Here's what all bloggers need to know. You all need to come together and push more news out about R. Kelly and don't feed into them people who's not helping with the butts turn people away. Yeah, you're right, Robert. Robert, that's what I've been trying to do, reading these transcripts, getting information out, because I've gotten a great amount of feedback from people saying that those transcripts has been helping them to understand what happened in court, see the truth. You're absolutely right. Mm-hmm. Yeah. There's a lot of people with good intentions. Yeah, sad. Mm-mm-mm. Hey, Ashley, what are you doing up so late, Ashley? Felicia, you going to night? You going to bed? Night, night. I'm about to hit the road too. It's pretty late. Bobby said Donnelly should have impeached some of those witnesses' testimony. This case was really messed up. And you know what the funny thing is, y'all? Also, stop letting the left hand know what the right hand is doing. Everybody is in the race to one up each other. It's sad. Stop reading what they're talking about in the chat. Stay on R. Kelly because this fight is about him. Don't stop reading. Don't stop reading. They're talking about The chat state. Okay. I will, Robert. Thank you for that. I will. Don't read. Don't read what they're talking about. I will stay going to bed. Yeah, Robbie, I am going to bed. It's just I got a quick whiff of energy for some strange reason. I don't know. It just came up on me. Say night night. Okay. Think I'm gonna listen to Robbie. Any more questions before I hit that good night button? Before I say a good night button? Before I say night night, HR says, Sylvia, I want to say you've been doing a good job getting news out. You have been working hard on Kelly and want to say thank you. No, thank you, Charles. Thank you. Thank you, guys. I believe Kelly is 100%. Where did it go? Where did his statement go? 100 issues I can think about 10 myself. Yep. Well, good, guys. I'm going to say good night. You guys have a blessed evening, and I am going to be back on in when I get up. So we can go over the other stuff. We can go over the transcript. Good night, darlings. Have a good one.